Our second case on the docket this morning is case number 24-2804, State of Florida, ex rel. Douglas Chertok versus Zillow, Inc. Mr. Jaco, whenever you're ready.
May it please the court, I'm Joe Jaco with the Gunster Law Firm with my colleague George Lemieux. This is the state's enforcement action, the real party at interest, against Zillow for its failure to comply with the Unclaimed Property Act, or the UPA. The trial court made 4 summary judgment rulings. We are seeking each of those rulings to be reversed.
Mr. Jaco, would you like to reserve any time for rebuttal?
5 minutes.
5 minutes, thank you.
Thank you. In those rulings, the trial court committed 2 errors. First, the court resolved disputed material facts. Second, the court misapplied the UPA, in particular to Section 102's general rule for unclaimed property. The UPA's public policy is, quote, to protect interests of owners of unclaimed property. And this court has said the state is the preferred custodian, not a private company. It cannot be that Zillow can keep $6 million that it admittedly does not own. I'll take this court's questions.
You argue that 717-11-11014 doesn't apply, the 3-year kind of tolling period, for a lack of a better word. Isn't the redemption of Mr. Chertok and the vast company interest in M&D at issue, an interest defined under both corporate law and LLC law to mean what we're dealing with here, right? So why doesn't that apply?
Thank you for asking, Your Honor. So Section 1101 is an equities exception. Section 102 is the general rule, which we say apply. Looking at subsection 4 of the equities exception, there's a number of different amounts, dividends, et cetera, that are listed. However, when you look at the merger-related documents, both in the certificate of incorporation, which is the former shareholder's rights to payment, and when you look at the merger agreement, which is Zillow's duty to pay those former shareholders, it says clearly the amounts are in cash. This is on...
Well, I mean, isn't a dividend cash? You don't normally get a dividend in, like Coca-Cola or something. You get money from the Coke company as your annual dividend, right?
That's right. So the dividend was announced by the former company, NMD, and in the merger, that dividend is now cash.
And the 4 says any dividend. So why doesn't paren 4 apply then?
Well, it's because what is the kind of money that Zillow holds is the question. The kind of money Zillow holds is cash. It used to be dividends when it was with NMD. But after the merger, post-merger, when Zillow has an obligation to pay the former shareholders, it's cash.
Wouldn't it also fall under the definition of a distribution and an interest redemption in 4?
No, Your Honor, and this is at a minimum.
Or other sum, also, or other sum.
Or other sum,
Yeah.
yeah. This is at minimum a disputed material fact, because when we, again, look at the merger documents, it says what kind of money Zillow holds for the former shareholders. And it explicitly says in the merger agreement, amounts in cash. It says in the certificate, cash. And Zillow even admits that it holds this money in its motion to dismiss. They say they hold this $6 million for the owners, and that, under the merger agreement documents, is in cash.
Would you agree that if paren 4 applies, there's no dispute that there was communication in the 3-year period?
Well, that's right. If it applied, then there's a question, there's a lower threshold of whether those communications expressed an interest. I don't concede that they do express an interest, but under Section 102, which is the proper statute to apply to cash, it's a higher threshold, which is it has to be failed to claim. And this court has said in its Humana case in 1992 that defining what a claim is a demand. And it's absolutely clear when you look at the court's factual findings for the 3 communications that occurred between December 2013 and December 2018. They were 2 emails from Zillow's counsel that went unresponded, and then an email to Zillow notifying them of an appeal. There's no way that those are demands for money. So the 102 threshold is certainly not met, and we wouldn't even say that the 101 is met as an interest.
Now, there was clearly a demand, I think both sides agree, in July 2019. And so why is the state filing a case in 2022 saying that there's unclaimed property when there's a demand was made 3 years prior and both sides agree this money is theirs, but they're bickering over the mechanics of the payments or whatnot? It seems like that takes out the definition of unclaimed. This is claimed money. It's just that there's this bickering going on about interest or about the who signs what and what papers need to flow with the money.
Thank you, Your Honor. So once that 5-year dormancy period ran in December 2018, the state takes custody of the money. So that
It's a May 1st date, I think that you said, as of May 1st, 2019.
that's so
And you made a demand in July 2019, so maybe there was 2 months in which something different should have been done, but at July 2019, you made a demand, so it seems like even at that point, if they have the money, their obligation is to keep it under the other statute involved in this act.
Well, 2 things, Your Honor. So one, the 5-year dormancy period ran in December 2018. So at that point, the dormancy period closes. Now, we say in our reply brief, that dormancy period used to be, in 1976, 15 years long. In 1986, 7 years long. Then it became 5 years. So the legislature clearly only expected claims to occur in that 5-year period. If they wanted to capture claims outside the 5-year period, they would have left the statute the way it was, 7 years, 15 years. So claims that happen beyond December 2018 do not matter for 102's operation of unclaimed property. Then, as you mentioned, in May 1st, Zillow had an obligation to report that unclaimed property. They didn't do it, right? So they violated the law. In addition, for things that happen beyond that 5-year period that sends the money to the state's custody, there were certainly some type of communication, but what the expectation is that first a holder would pay the money to the owner. So if that had happened here, great.
Well, weren't they? It seems like the record suggests they've been trying all along.
Your Honor, I mean, one, that's a disputed material fact, right, on whether they have or haven't, but they certainly haven't. I mean, Zillow hasn't paid the money to the owners. They haven't paid it to the state of Florida. They haven't even paid it to New York, where they say it would be due. The point of the UPA is to ensure that a company like Zillow doesn't hold money it admittedly does not own.
You raised the various states involved issue. The 717-1031 talks about the last known address as shown on the records of the holder, which would be on Zillow's records. My understanding is that all times material, Zillow's record showed that Chertok and Vast were New York residents. So I think that's like the third ground for granting summary judgment, but why is that incorrect?
Thank you, Your Honor. So first of all, the court moved to summary judgment when we still had discovery ongoing about this record of Zillow's. We haven't seen it. It's not been verified. So we don't exactly know what the record is. Our discovery was cut short. But in terms of the interpretation of 103, let me say 3 important things. First is that there's a due diligence obligation on Zillow. This is found in 117 subsection 4, and that is on any inactive accounts over $50.
So even though Zillow had a apparently valid New York address for both Vast and Chertok, they nonetheless needed to do due diligence in all 50 states and see where they may be residing, even though they know exactly where they're residing? I mean,
Well-
that doesn't make any sense to me.
Well, Your Honor, people move. I mean, so
But
this.
they didn't have any knowledge that they moved. Certainly, if they moved and you've sent, a certified letter and it comes back, undelivered, then you've got some obligation. But apparently, all the communications had been received. Right?
Well, Zillow didn't send any kind of certified letter to the owners, trying to verify their address. And, the way the UPA is written is not an obligation on the owners to notify. All of the obligations are on the holder to do
Once it
diligence.
becomes unknown, but isn't that the trigger here, that there's got to be, before there's due diligence, there's got to be some unclaimed property and the owner's got to be unlocated, right?
Your Honor, that's not how the statute reads. I mean, section 117.4 says on inactive accounts over $50. That first sentence says nothing about unclaimed property. So that due diligence obligation is just on once a company has an inactive account over $50. And if Zillow decides to do business in all 50 states, then yes, presumably it should be doing this in all 50 states. But that's why the statute lists types of due diligence, such as hiring a company to go out and check public records. If Zillow had done that, as it should have, prior to every May 1st, it would have easily discovered that the owners were in Florida in 2018. I mean, we list multiple records that demonstrate the owners living in Florida. And even Zillow's own website shows that the owners lived in Florida in December of 2018.
When
So-
you say, we've been saying that when the state took custody of the property, did the state actively do anything, or are you just talking about by operation of statute, that it's implicitly goes into the custody of the state?
By operation of statute, that's 103.
All right. And then was there any active communication between Zillow and the state where Zillow in some way was disguising or concealing to the state? I mean, active communications, where they're doing anything affirmatively to hide the ball for the state as the state is trying to take custody of this property.
So we don't know of any communication between Zillow from the time the money was deemed unclaimed and the state would have taken custody of it under Section 103 and this lawsuit. But the fact of the matter is that's why the statutes put the due diligence obligations on the holder, that they are supposed to go and engage in these various methods
Well,
to
but
find out where
there
the owners
seems
are.
to me at least to be a difference between a requirement for due diligence and, under the False Claims Act, where it makes it a problem was it knowingly and improperly avoid or decrease an obligation to pay to the state? I mean, there seems to be something more required before you run afoul of the False Claims Act than just not doing due diligence, right?
So Your Honor, two things on that. One, the false claims aspect of this case hasn't been adjudicated yet, right?
Right.
It's not, that wasn't in any part of the trial order. But second, so under the False Claims Act, subsection, this is 68.082 subsections 2 and D, we say that there's a false claim because they knowingly delivered less than they were obligated to. And so at some point in this timeline, from December 2018 or when they were first due in May 2019, through the litigation, there was at some point that Zillow knowingly did not deliver. We will prove that when this case goes back to trial. And so that will be addressed.
And did you all file a motion under the summary judgment rule saying, the requirement that if you think that there's more discovery to be had, and that, so you can't properly or fully respond to a summary judgment motion. Was that motion filed?
Your Honor, we had 5 motions pending on further discovery, and so.
But did you specifically file a motion under the summary judgment rule?
Your Honor, I'd have to get back to the court on that, and I can file something supplementary on that. But let me at least go back to the question I believe each of you has asked in relation to the state taking the custody under 103. So I mentioned the due diligence obligation. The second piece is the last known address. And there's a clear distinction in the applicable statute, which is 103, and in a statute like 107, which is for life insurers. So this court in the Thrivent case looked at 107 and said that it's the record that establishes the last known address, right? So whatever the record says is what it is. The wording is very different under 103. It says the record must show or must reflect, right? And so the record has an obligation to make evident or to be a faithful image of what we know the last known record is, last known address is. And that last known address is clearly known by the public records. I mean,
Is there only one last known address, or can there be multiple? I mean, it seems like the definition of last known address talks in terms of a place where the person can get mail, and so people could have 10 of those, it would seem.
Your Honor, I think this is part of the due diligence exercise, right? So the definition under 101 subsection 15 is the location of the owner. So that Article V implies that there is one location, and the record needs to describe that. And a way that a holder would be able to describe that is doing their due diligence and identifying all of these public records that show that address is here in Fort Lauderdale. Another important piece under 103 is subsection 3. And there, it talks about the records must reflect the last known address, and if they don't, then it can be established elsewhere. So we know, based on the statute itself, subsection 3 of 103, that the last known address is something independent of whatever record Zillow has. In this case, whatever stale record Zillow has. That independently found last known address is through due diligence.
Does the record reflect that the New York address was a return to sender? Like, nothing would have been delivered there because the owner was no longer there, or Mr. Chertok was no longer there?
If they had mailed it, but they never mailed it, right? Zillow admitted in their deposition they didn't do 1 ounce of the required statutory due diligence.
But there was a lot of back and forth. I mean, the whole time it seems like you all are at each other in different forms of litigation, and so you all are receiving each other's mail. It would seem. So my question is the New York address a dead address as far as Vast and Mr. Chertok goes, or is it just not the principal address?
It's not where they are. It's not the location of the owners. So Your Honor, you mentioned other litigation. In 2019, there was a lawsuit that listed the owners in Florida as a Florida liability company. This is something that Zillow clearly has in their records. And one of the due diligence requirements is cross-referencing your own records. So we know as a fact that in 2019, Zillow knew the owners were in Florida. And they just continue, even today, I think.
But at that point, the property had been claimed. You had sent a demand for it. I mean, it seems to me like there's a 2-month window, May to July, where, okay, there's a dispute over whether this property was unclaimed or not. But when you made a demand in July of 2019, that was claimed property. Everybody was on the same page. They identified the sum somewhat, and it was not, it became it was unclaimed. It became claimed property that had not yet been delivered, received, the statute uses other words, delivered over, paid over, dispersed. But it seems like at that point it became claimed property, so that they couldn't have given it to the state.
Well, Your Honor, let me be very clear. So there was no claimed property during the running of the dormancy period. So once that concluded, and once the statute put the property in the state's custody, there's no statutory mechanism to undo that. It's the state's custody of the property in early 2019. So even if there is some subsequent communication, that doesn't undo the fact that the state has custody. That only means that Zillow has even more of a requirement to either pay the owner directly, that's legitimate, or custody. And let me get to that, because that's the court's fourth ruling that goes into section 119.3 and mentions, this idea that you have an erroneous presumption. 2 points about that. One is the court didn't identify anything erroneous about the operation of 102. The money was payable in December 2013 to start the 5-year period. I don't think there's any dispute that Zillow owed the money to the owners in December 2013. It's payable. That's the only time it needs to be payable, is to start that dormancy period. And then there's no claim during those 5 years. Again, I don't think there's any dispute.
No claim. What was the Delaware litigation over?
Well,
There was a claim. They sued in Delaware, and that were affirmed by the Delaware Supreme Court.
right, one, Your Honor, that litigation happened after the 5-year dormancy period, right? So my point is that in December 2018 to early 2019, it's in the state's custody. Whatever Delaware says about the owners not having a contract remedy anymore because the statute of limitations has expired, that does nothing to halt the state's enforcement action in the state's custody.
And you're correct. Let me apologize to you, but I've mixed up the Delaware and the New York. There was a New York litigation going on in 2017 during that 5-year period, right, over a settlement agreement.
So, in Honor, that's probably the very reason why there wasn't a claim, because that litigation had nothing to do with this amount of money, this $6 million. That litigation had to do with intellectual property rights. It had to do with, the fact that the company was, from the owner's perspective, sold out from under them. It had to do with other issues related to the merger, not the amount of money. So during that 5-year period, the owners didn't want to pursue the $6 million because they were litigating over the company itself, which was what they would rather have, and their intellectual property rights, which they wanted from the company. They didn't want to acquiesce that federal litigation in some way by claiming this property. So that's why you don't have a claim during that time period, during that entire federal litigation. But in terms of the other Delaware litigation, all of that's subsequent to the running of the dormancy period.
Your time has expired, but why don't we do this? Why don't I give you a couple minutes for rebuttal, and let's add 5 minutes to the appellee's time, and we'll go from there.
Thank you, Your Honor.
Thank you. Mr. Jackson.
Thank you, Your Honor. May it please the court. I'm Ty Jackson, along with my co-counsel Jason Unger. We have the privilege of representing Zillow in this matter. Your Honors, this court should affirm the court's judgment in favor of Zillow and denying the relator's summary judgment for 4 primary reasons. First and foremost, as is apparent, Mr. Chertok is not missing. He's never been missing. He's certainly not missing today. There is no unclaimed property. The Unclaimed Property Act has no business in this case. The relator has brought this case as the relator. It's not brought by the state. It is brought on behalf of the state. The state looked at this, said, we're not going to intervene in this. Mr. Chertok deposed the Department of Financial Services Division of Unclaimed Property representative in this case, who had been with the division for 23 years, who said, this is not unclaimed property. Clearly it's not unclaimed. Mr. Chertok clearly knows about it. He's aware of it. Don't send it to us. We would just have to process it to send it to him. It's not unclaimed. We don't want anything to do with it.
So your point is, it's been claimed property all along, it just hasn't been delivered yet?
Well,
Or
Your Honor,
something along that line?
I would contend and will contend there is no property here that's
Well,
due
your
or
motion to
payable.
dismiss admitted that we're trying to send them money, but we haven't worked out the details essentially yet.
Yes, Your Honor, under the merger agreement. The merger agreement and the NMD certificate are two separate standalone bases for this potential property to be owed. Zillow has maintained since 2013 that if the relators and Vast Ventures, who he owns and controls, had satisfied the conditions precedent under the merger agreement, which the evidence in the record in this case shows he has never done, he would have been entitled to property under the merger agreement. He's never done that. And in this case, he said in the complaint, we're seeking the property under the NMD certificate, not the merger agreement. He underlined, bold, and italicized the word not in his complaint. I asked him about that in his deposition. He very clearly testified, I'm not seeking this under the merger agreement because he knows, one, he doesn't get interest under the merger agreement, and two, he's never satisfied the conditions. Under the NMD certificate, there is no property. That's essentially a breach of contract claim. He says, you breached the contract, and we said, no, we did not. If you look at the certificate, if you look at the complaint, he clearly says the certificate, you look at the certificate, it talks about distributions, dividends. Zillow has maintained from the beginning they don't owe him anything under the NMD certificate, never have. He sat on those rights until December of 2019 when he sued in Delaware. Delaware Supreme Court said, you missed the boat back in December 2016. There is no property that's due or payable to Mr. Chertok or Vast Ventures under the NMD certificate, never has been, never will be. He has no right to establish it. Florida has a statute, 95.10, says if the statute of limitations has run in the state where the claim arose, you can't bring it here. He can't bring that. He's attempting to revive his stale rights by bringing this case. So there is no property. As the trial court correctly found, even if there was property, it's not presumed unclaimed. I would respectfully submit to you the trial court correctly applied the 3-year dormancy period in 717-1101 sub 4.
Well, one of their arguments is, well, that doesn't apply because the dividends got converted to cash. What's the response to that?
Well, Your Honor, your point exactly. Dividends are given to you in cash, but the point of 11014 is that these are sums that arise out of equity interests in a business. It talks about dividends, distributions, other sums payable to a shareholder as a result of their equity interest in the business. That's exactly what this is. There were dividends, and if you look at the complaint, they say that the merger consideration, as they define it, arises out of the NMD certificate, Article 4th, Section C, paragraphs 2.2 and 2.3. The title of 2.2 is distribution of remaining assets, and it talks about distribution if there's an event such as a merger. These are clearly dividends and distributions to shareholders arising from their equity interests. The 3-year dormancy period in 11014 is exactly what applies. Even 102 explicitly acknowledges at the end of the sentence of the section that they cite to, the 5-year, except as otherwise provided. It acknowledges there are specific types of intangible property that are subject to specific periods. I would also point out, Your Honor, there is a rule that defines presumed unclaimed. And that rule states, says presumed unclaimed means, quote, the apparent owner has not indicated an interest in the property for the applicable prescribed period. That rule implements 717-102 and 1101. So I would argue that even if the 5-year applied, it's still, if the owner is apparently aware of the property, it's not unclaimed. But going back to the 3-year, there was ongoing litigation between December 2013, if that's when the dormancy period started. We contend it did not start ever. But if it started in December 2013 and went through December 2016, there was ongoing federal court litigation over the issues from the merger. Mr. Chertok and Bass were trying to overturn the merger so they could get this alleged money through a different route, get the interest on it, get their ownership interest back in the company. It related to the issues in this case. They obviously were aware of one another. They were steadily communicating with one another throughout that litigation that didn't end until May of 2018. They also had emails during that time period that are in the record where they were communicating. There was a sanctions issue. Zillow's counsel emailed Mr. Chertok's counsel and said, hey, realize you got sanctioned. We got this issue. Can we get this worked out? His counsel wrote back and said, I don't represent Mr. Chertok anymore, but I've sent your email on. A couple days later, Mr. Chertok responds to Zillow's counsel and says, I've filed the notice of appeal, and we're moving forward. So it wasn't unclaimed, but even if it was unclaimed, as of December 2016, it's undisputed in the record that Mr. Chertok and Bass Ventures were actually still in New York. Set aside the address of record issue. They had no connection to Florida in December 2016 whatsoever. So if you agree it's the 3-year dormancy period, even if you find that the court was wrong, that it was never presumed unclaimed, it would have gone to New York. There was no obligation to send it to Florida. Their next argument is, as you know, well, it should be the 5-year dormancy period. Again, the rule defines presumed unclaimed that applies to all of the Unclaimed Property Act. I don't agree there's a difference. It was not unclaimed as of December 2018 for the same reason it wasn't unclaimed as of December 2016. Even if it was presumed unclaimed, it still doesn't go to Florida for a couple reasons. One, Bass Ventures LLC, a Florida limited liability company, in the record, did not obtain any interest, even potentially flowing from the NMD certificate or the merger agreement, until May 6th of 2019, which is after the property allegedly should have been sent into the custody of the state on May 1 of 2019. So it couldn't have been subject to a sheet to Florida in 2019. But aside from that, the address of record, as shown on Zillow's records, to this day is New York. And to this day, it's New York because even throughout this litigation, when we said, do you want us to change your address to Florida? Refused to do it over and over again, refused to answer those questions in the deposition, refused to say, yes, change my address to Florida, has never sent a request to Zillow to change his address to any address other than the one in New York that they've had since 2013 when NMD merged into Zillow and Zillow received NMD's records that showed the address of record for the shareholders in NMD. That's how they got it. As to the evidence, Ms. Cartalas, which is Zillow's rep, in sworn interrogatories, said the address of record as shown on Zillow's records is in New York. In her testimony and deposition, by questioning by Mr. Chertok's counsel, she said address of record is in New York. In a declaration, she said that. Repeatedly, she said the address is record. They said, where did that come from? So we provided the actual document where NMD Interactive provided the addresses to Zillow as a part of the merger. It's part of Zillow's business records. Ms. Cartalas testified to that. It's not unauthenticated. It's been authenticated. It's not hearsay. It's a business record. That's shown up in the record. But I would submit to you that's irrelevant. We have specific testimony from Zillow that that's the address on their records. You don't need anything further. And there is not even a scintilla of evidence, not that that would be sufficient, that the address was something else on Zillow's records. If you look at the admitted complaint, it's devoid even of any allegation that Zillow had a record that showed a New York address for Chertok or Bass. It's not even in the complaint. The complaint's completely deficient on that reason anyway.
Can I just ask, functionally, is there a difference between being in the custody of the state and the state actually owning it or being property of the state?
Yes, Your Honor, there is. That issue did not come up in this case specifically because we have so many reasons, but there's currently a case pending in the federal district, in the Northern District of Florida, where a class action, they're trying to get it certified as a class, is suing the state of Florida, claiming that the interest that the state tries to keep when it has money in its custody is an unconstitutional taking, because unlike a true escheat statute, the Unclaimed Property Act is a custodial statute except for very specific types of property which are not at issue in this case. The state, to your point, takes custody, and the statute says as soon as they identify the owner comes forward, they must give them over the money. They're just taking custody of it. Right now, they take custody of it, they put it in the school trust fund, they earn interest on it, they keep that money, they give back the principal. This suit, it was filed in the Northern District, it went up on appeal because it was dismissed. The 11th Circuit said, no, I think there's something here, so it's back down in front of Judge Hinkle, I think it is, currently, before the court, alleging a Fifth Amendment taking, because it's
Sure.
not.
So then make the distinction between, what is the relationship of a custodian to a possible owner of that property and an actual owner of the property? I mean, presumably, there is a difference between those two relationships, right?
Yes, Your Honor, there is. And we did
Like a
address.
custodian doesn't have a property interest in the property that has custody of. It's holding it almost in trust for someone else. Is
That's
that
correct, Your Honor.
a
Under
fair
the, under
reading?
the Unclaimed Property Act, the state is holding it as trust for the owner, which is why when we deposed the division's representative, they said, don't send it to us. He obviously knows about it. We'd have to hand it over to him. And interestingly, and this is in the record, Mr. Chertok currently is suing an entity for allegedly improperly turning over property to the state of Florida as unclaimed property when he was in communication with them about a merger out of which this money arose. The case is still pending in the south part of the state. It was in state court, federal court, went back to state court. I think it's now back in federal court. But he's actually taking the exact opposite position in that case. He contended in his deposition when I asked him about it, well, I'm not here as Chertok, I'm here as the state. That's Douglas Chertok individually, so those things are not inconsistent. They are.
So, this case comes as we have judgment in your client's favor, right? So it knocks out the complaint, it's res judicata. And what that is essentially saying is that they don't have a False Claims Act suit against your client.
That's
Do you agree
correct.
with that? So we could affirm on any basis appearing in the record, including, is there actually even any cognizable claim under the False Claims Act, right?
Correct, Your Honor. And
So I asked you the same question I asked Mr. Jaco about, looking at the False Claims Act. So if the state at best would have custody and not actual ownership of it, is a fair reading of 68.082, in particular, say 2G, is a fair reading of that include, well, the state actually has to have some sort of ownership interest in the property for it to be a false claim?
I would posit to Your Honor that it does. And the legislature actually, after this came about, the legislature actually considered putting something in the statute to make that clear. It was in a bigger bill and didn't go through.
Sure.
But the Division of Unclaimed Property very clearly thinks that this is not an appropriate False Claims Act situation.
I mean, has there been another example of where the False Claims Act has been used in this manner to enforce an unclaimed property?
Your Honor, I'm not aware of one. I'm not aware that one has come before. I mean, honestly, again, just looking at it from a distance and saying, okay, the alleged apparent owner is here saying that there's unclaimed property that should be escheated to the state. He is the alleged apparent owner. He is here. He obviously has knowledge of this purported property. The Unclaimed Property Act has no place here. And I think the trial judge in the final summary judgment said, look, clearly, at least when he filed this lawsuit, he had knowledge of the property and it wasn't unclaimed. And under 1193, it clearly says if for any reason it appears that it's erroneous, the presumption that it's unclaimed, you don't turn it over to the state. Mr. Chertok's response to that is, well, yeah, but you're supposed to send a statement to the state telling them that you think that it was erroneous. Well, Zillow never thought that it was unclaimed or that there was any right to property under the NMD certificate or the merger agreement, so they didn't send anything. But to your point, Your Honor, even if they were supposed to provide a statement, that's not property. It can't support a False Claims Act case. And we did, in the pleadings in this case, we did talk about the fact that it has to be knowing and improper failure to pay it over. They've certainly not showed that they've not shown that Zillow thought they had an obligation to pay any money or thought that it was presumed unclaimed. They certainly haven't shown that it was knowing and improper. And to Your Honor's question about discovery, we filed an earlier motion for summary judgment. And Mr. Chertok argued, we can't go to summary judgment yet, we need to do more discovery. After that, they did numerous depositions, additional discovery. This was one of the most heavily litigated discovery cases I've ever been involved in. I mean, just numerous motions to compel, to sanction me for allegedly not complying with discovery, none of which were upheld or granted. But there was extensive discovery after the filing of the first motion for summary judgment. There were motions that were filed at the very end, at the close of discovery, saying we need even more time, but those were filed a couple days before the discovery period was to end. There was plenty of chance to do discovery. There's no facts to support their case. Your Honor, I see I have time left. If there are other questions, I'm happy to take those.
Mentioned all the litigation going on. One of your issues, you filed a motion for appellate attorney's fees. If we agree with you and affirm the summary judgment, is that something that we can decide? You know, I hadn't seen a lot of qui tam actions. Is that something that we decide? Is that something we kick down to the trial court? Or her findings on the consistently and repeatedly pursued Zillow sufficient? What would, if you win, what would you have us do on that?
Your Honor, if we prevail, and again, I think we prevail for a lot of reasons, but the one to me that is just the most obvious is that Mr. Chertok is here. He's obviously not missing. He's not been missing ever. He certainly hasn't been missing since he filed this lawsuit. The trial court entered a finding that he knew all along that he was not missing and that this case had no merit. We have a motion for fees pending in the trial court. She stayed that pending the outcome of this. We filed a separate motion for appellate fees. I think, Your Honor, you all would be looking at the motion, assuming you rule in our favor, you would look at the motion to determine whether or not it meets the standard for fees on appeal, either grant or deny that. If you grant it, my understanding is that would go back down to the trial court to determine the amount of fees, which I assume at that time she would also take up our motion for trial fees on the same grounds and take a look at that.
Thank you.
Your Honor, if you have no further questions, for the reasons we've talked about today and for the additional reasons that are set forth in the answer brief filed in this matter, we would respectfully ask that you affirm the trial court summary judgment in favor of Zillow. Again, if you find any one of the reasons that the court found, many reasons, you're required to affirm, and that you should deny the summary judgment or affirm the denial of the summary judgment for Chertok, the relator, on the same grounds. Thank you very much.
Thank you, Mr. Jackson.
Your Honors, Zillow is a big company. If it is allowed to bury its head in the sand and keep $6 million it admittedly doesn't own, it's going to incentivize other companies to do the same thing, to earn interest on that money, to avoid legal obligations, when the entire purpose of the UPA is to remove the money from Zillow and either give it to the owners or for the state to hold it until the owners come forth or the state identifies that it should go to the owners. But the one thing we know, whether the money goes to the owners or to Florida or New York, it should not stay with Zillow, and that's what the trial court's opinion does. Your Honors, let me address a few things. First, Judge Tannenbaum, you asked about the False Claims Act. 67.0822G allows for a false claim when Zillow knowingly avoids an obligation to transmit, quote. So that is what they're doing by holding this money and not giving it to the state when the state has custody.
Yeah, but what's the state going to do when it's transmitted?
Your Honor, the very point of the UPA is to get it out of the hands of Zillow. Once the state has it, if there's an owner, presumably they'd give it to the owner. In this case, Zillow's unwilling to give it to the owner. So it's just holding the money. It's been holding the money for 12 years. And so the operation of the UPA is to allow the state in this instance to appropriately give it to the owner. But that's the violation of the False Claims Act, is right there in subsection
But under your theory,
2G.
either Zillow is like the custodian of this property, or the state is custodian of this property, holding it for the benefit of your client. And it's kind of like a fiction to say it's actually needed to be transmitted, and their failure to transmit it to the state is a false claim. And I'm having a hard time following that. If the state doesn't have ownership in it, doesn't have an ownership interest in it, and your client's claiming ownership interest in it, and it really doesn't matter who actually has it, I'm still not following where
Well,
the
this court
claim
said-
actually arises.
This court has said clearly in Petronas' case that the state is the preferred custodian. So that's clear. It should be with the state, not with Zillow. Whether at that point there's a violation of the False Claims Act, we would say that it's right there in the failure to transmit, but we would submit that to the jury and let the jury decide. If I can quickly, let me address 5 things that my friend.
Your
No,
time
I'm
has
just gonna-
expired,
I'm
Mr.
gonna
Jacob,
rapid
but
fire.
you may briefly conclude.
Okay, but then I want to address the 5 things, but they're all in our papers. But Your Honor, this idea at the very end of the owners being missing, the UPA operates either way. If they're missing and the state can find the owners, fantastic. And the money can, if the company is unwilling to give the money to the owners, then it goes to the state to go to the owners. If, as the Department of Financial Services testified, the money can be given directly to the owners, then they don't need to be a part of it. And that's all the department was saying, is we don't need to be a part of this if Zillow gives the money to the owners, but Zillow can't keep it. Thank you.
Thank you. All right, that concludes